So I was startled out of bed this morning by a million Twitter notifications that I needed to stop playing Breath of the Wild and start looking at why people were getting trademark takedowns on YouTube. What? Hello everyone, I'm Leonard French, your favorite copyright attorney, but today I'm here to talk about trademarks and how in the world people are getting issued trademark takedowns on YouTube. Now, at first glance, I thought maybe someone had really misused someone else's trademark. A trademark is used to identify the source of goods or services. This is a very good thing. We want companies to be able to invest in their branding, and we want consumers to be able to rely on the source of their goods. If you like a certain detergent, you may be able to identify it by its color and smell, and the shape of the container or the style of the label. All of those things are meant to protect a company's brand as well as identify the source of the goods to consumers so they are protected as well. They know where the goods are coming from, and other companies can't legally create counterfeit products. So we're mostly talking about the use and the protection of the trademark against counterfeit use and the protection of the consumer against counterfeit use. Well, what we're seeing here on YouTube is just more of an attempt to silence free speech using whatever means necessary. If we can't get a copyright violation through, let's try a trademark. At least that's what I'm seeing from two cases that just popped up with Jimmy the Freak Nitro and, of course, everyone's favorite Jim Sterling, because he deserves another one of these right after he just kindly settled the one before, right? So it appears that a company called STICLI Games has asserted a trademark takedown on a Jim Sterling video that was reviewing one of their airport manager games, Airport Master, something like that. And they have this end-user license agreement that I'm going to have to go check out myself, but the part that I'm looking at here says that the end user recognizes that all of the rights associated with the software, as well as the rights related to trademarks, copyrights, royalties, are the property of STICLI Games. Okay, any use of the copyright holder's trademarks, imagery, videos, graphical elements, name, plot, etc. is only possible with prior written consent. Okay, so what it looks like they're trying to do with that clause is it is to stifle criticism ultimately, but the clause on its face purports to give them the right to approve your republication of any content. It seems to include copyrights and trademarks and yada, yada, yada. Unfortunately, that's not the end of the inquiry. First, this is contract law, and you can make contracts regarding your intellectual property. You can make a contract regarding your trademarks and your copyrights. And so on its face, two parties could get together and sit down and negotiate a contract that includes one person agreeing not to infringe on the other's trademarks or copyrights or use them in any way, etc., etc., etc. Now that's how a contract is normally negotiated, except that we're in 2017 and everything is online and nobody wants to read contracts and negotiate them anymore. So we have all of these contracts that are set in stone, written by a lawyer months or years ago, sometimes not written by a lawyer at all, and placed onto a confirmation page or pre-confirmation page on a purchase screen that says, by the way, before you pay for this thing that you know you want and you're ready to buy, and you've given us your credit card number, just click that you agree to this end-user license agreement. Even as an attorney, I read remarkably few of them. This is probably the first one I'll have looked at in months. So this is what we call a contract of adhesion. You don't have a choice. You are a consumer. you are coming to buy a product, and you must agree to the agreement if you want to enjoy the product. Yes, those agreements can contain certain clauses, and those clauses are upheld in court all the time as having been agreed to by the parties. But clauses that have nothing to do with the agreement and are only one way, usually in favor of the writer of the contract of adhesion, they'll be scrutinized by the court a lot more strongly. Contracts of adhesion that contain clauses like this will usually have that clause stricken if it's challenged in court. Or at least it will be modified by the court to something much more appropriate. In a case like this, with a game developer who has specifically asserted their trademark rights and contract rights in order to stifle a critic from making a critical video using their in-game footage, that's probably going to get thrown out of court. I mean, not the claim. I mean, the STICLI is probably going to get thrown out of court. Yeah, so this is what I would call misuse of an end-user license agreement. They're allowed to make an agreement with you regarding the terms of your use of the software. What they're not allowed to do is really go outside the bounds of contract law, and contract law does have boundaries. There are some obvious things that you can't make contracts for, but then there are some very gray things that you can make a contract for, and it sounds like it would be legal, but then it's not. The most common one that I can think of that most people call a lawyer about is a non-compete clause in a employment agreement. You might work for someone for a period of time, and then after you either quit or you are fired, they say that you can't work in that field for a year or two or more. And a lot of those clauses are either illegal or limited by law or limited by case law, because people generally do have a right to go and compete in the employment marketplace, and it's very rare that someone would have an employer would have the right to completely eliminate someone's employability. It says here, you may not reproduce, distribute, publicly display, publicly perform, or otherwise use the software except with prior written permission of licensor. Except and solely to the extent such a restriction is impermissible under applicable law, you may not decompile, reverse engineer, etc., etc., etc. And then it does go into clause 4. The end user recognizes that all the rights and associated with the software, as well as trademarks, royalties, etc., 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 are protected by international laws and treaties and are the property of STICLI Games. This is on a borderline, but it's pretty clear. It's a pretty clear borderline. You may know that companies like Nintendo enforce their copyrights against streamers and don't allow unauthorized streamers to stream Nintendo games, put their videos on YouTube, or at least they were being pretty heavy-handed about taking down just basic streaming like that. Now, the difference between streaming and what Jim Sterling was doing in criticizing a game are two different things under the law. And his criticism may be a protected fair use, whereas the streaming for profit may not. You're allowed to make critical videos as fair use, but streaming videos aren't necessarily commentary. They're more so you enjoying the game while republishing the content, and there's a much stronger argument against fair use for raw streaming than there is for commentary and news reporting and critiques like what Jim Sterling's doing. And what would be the remedy anyway? It isn't like we have a Section 512F of the DMCA as a cause of action to sue for misuse of trademark. Well, that's not entirely true either. It is possible to sue for a misuse of trademark and a silencing of one's rights to criticize and rights to make videos and publish them online and have your trademark in the background. Again, Trademark is meant to represent the source of the goods. So unless you are misrepresenting the source of the goods, or unless you are creating a confusingly similar trademark to represent your own goods or services, then that's not a violation of trademark. You are allowed to use the name and image and all that of the product when you are referring to it for otherwise protected speech. That's not what I understand anybody did here. So why in the world this would be done, there's really only one reason. These companies, these developers, these people don't like these critical reviews, don't like their product being shown in an unfavorable light, and so they issue a takedown because what are you going to do about it? That's really the dare here, is what's Jim Sterling going to do about it? Is he going to sue them over this? He may have to. And it's going to cost them a pretty penny again. And we're all going to make videos about it, and hopefully the community will come together and donate again, and we'll figure out how to get through this one. And maybe this one will set some legal precedent, because as of right now, I found very little case law on using trademarks to silence online criticism. I wanted to do a lot more research, but I also wanted to get a video out for you. So this is going to be an off-the-cuff and short video, but this is just absolutely appalling. How in the world... Why can't these people just figure out how to use their trademarks and copyrights properly and let everybody else use the trademarks and copyrights properly? This is nuts. What's the remedy here? How do you fix this? Well, aside from Congress changing the law to make it easier for people who are victims of this kind of thing to sue, or maybe making a separate cause of action that has its own set of penalties for misusing a copyright or trademark, someone has to go to court. And someone has to go to court and set these precedents, and someone has to pay for that. The most I could come up with was maybe some kind of insurance policy. I don't know if Google would sponsor something like that, but some kind of insurance policy where if you follow a set of guidelines and principles, Google will support you up to $100,000 or something in a copyright or trademark takedown dispute. I don't necessarily know how much of a cut they're going to want, maybe another 10-15% of your revenue in order to protect you. And that would be very, very complicated, because there would have to be a team of fair use attorneys on hand at all times to be evaluating these claims that were constantly coming in and out. And I don't think Google wants to be in that business at all. I think Google just wanted to host videos and profit off of the advertising, and this is getting very, very, very complicated. So, holy crap. Jeez. Jim's gonna have to sue or have his lawyers make some really good threats, because this is nuts. This is not the way a license was meant to be used to stifle criticism and free speech. I might make a longer video about this later when I've had a chance to look into it more. Like I said, I just woke up to this, and these are my initial thoughts on using trademark takedowns, using trademark notice. There is no such thing as a trademark takedown notice, by the way. YouTube does not follow some safe harbor law in trademark to affect this. This is a private policy that YouTube has in place. There is no such thing as a trademark safe harbor provision that YouTube is trying to maintain here. This is probably a private policy that they have in place, that they will take down videos for alleged trademark violations, probably to achieve some kind of safe harbor if they're ever to taken to court as some sort of contributor to some infringement. But it's not like they have a duty under the law to do this. They could also be referring the parties to the court system at first instead of taking anything down and forcing the plaintiffs to get some kind of court order. I think they're just afraid of the plaintiffs who have more money than the small-time creators do in most cases. So that's what I think's going on here. I think STICLI is taking advantage of the system. I think they have written an overly broad contract in the form of their end-user license agreement that will not survive scrutiny in the courts. I believe this is a contract of adhesion. I believe that they don't have the right to limit certain fair uses of trademark and copyright in a contract of adhesion. This is a consumer contract. I don't think they have the right to limit free speech, which I realize is against the government. This is not the government, but I don't believe they have the right to limit your fair use of their trademarks and copyrights in a contract of adhesion in a consumer agreement. So, or an agreement for a consumer product. So, now maybe they would argue this is a license agreement not for a consumer product. So I guess it will depend on what state this is adjudicated in. I did not see a location designated in their end-user license agreement for where these contracts are adjudicated, so I'm assuming it's probably California. And California is fairly savvy when it comes to consumer protections, so I don't expect this contract to survive as is if it were challenged in court. Now, somebody has to go do that. Is it a $150,000 inquiry? No, but it's still going to be a multi-thousand-dollar inquiry by an attorney in the appropriate state. So it is definitely a burden on the parties. I do want to give a special shout out to Joshua Meinzinger, I hope I've pronounced that correctly, who has sponsored my videos at the $50 level this month. So thank you very much, Joshua. I really appreciate your support. And everyone else too, who's been scrolling on my my little LED panel to my left, your right. So I will probably get a longer video on this topic out at some point, and I'll be following this issue and making an update video if it seems to keep going the way of the dodo. Anyway, so thanks for watching, and have a great week and a great Sunday.